I forgot what I was going to ask.
Okay.
But
well, moving right along, then.
Thank you very much, and thank you for sticking around with us. Ambassador Hale, I was in the middle of asking you a question about your perception of legal authority for hostilities. Some of us are concerned about the way in which the president construes his inherent Article II authority. And so I wanted to just confirm that there are really two legal justifications for a military strike against a country like Iran. The first would be that we are responding to an attack or we are attempting to prevent an imminent attack. That would be, as Mr. String has articulated, within the president's Article II authority. The second would be that the administration comes to the conclusion that there is an existing congressional authorization that would cover such action, or the Congress passes a new authorization. But I just want to make sure that I'm right in general, that the two ways you could strike Iran is if you are responding to attack or defending against an imminent attack, or you have an authorization from Congress.
Well, thank you, Senator. Those do seem to be fairly specific legal questions. Would you mind if the acting legal advisor responded?
I don't, as long as we get an answer.
Sure.
I was maybe hopeful you might give a little bit clearer answer than we've gotten from Mr. String, but I'll put it to Mr. String.
Thank you, Senator. So under U.S. law, I think your question is under U.S. law rather than international, but under U.S. law, there would need to be an AUMF, an authorization for the use of force by Congress. And as we've stated, there's been no determination to date that either AUMF would apply to Iran. And then secondly, you talked about the constitutional authority. In previous OLC opinions across administrations, the authority has been described to be a little more flexible than what you stated. So there needs to be a precise national interest that's been articulated by a president in order to justify the use of force under the Constitution. Some of those types of national interests that have been identified in the past are protection of U.S. persons or property, support of allies, support of UN Security Council resolutions, promoting regional stability, and deterrence of the use of WMD. So it's a little more flexible than you described, Senator, but it's broadly in line.
Yeah, I think the issue that you will find with many of us is that that list would seem to describe almost any reason to use broad Article II authority to engage in hostilities. And so I think there will be a difference between our interpretation of that Article II authority and your Article II authority. Mr. Hale, I wanted to follow up on your opening statement regarding the present situation with Iran. There's been a great deal of confusion as to what the administration's position is with respect to negotiations with the Iranians. Say what you will about President Obama, he was pretty clear that he wanted a negotiation on their nuclear weapons program and setting aside their other malevolent activity for future negotiations. The Iranians have telegraphed a potential interest, perhaps on terms that are acceptable to us, but an interest nonetheless to enter into negotiations. Is the United States prepared to sit down and talk with the Iranians if the subject is limited to their nuclear program or their potential nuclear weapons program, or are we still insisting that they commit to opening up negotiations on a host of other activities before we would entertain any discussions?
The objective of our entire strategy here is to seek a negotiated outcome with Iran that's comprehensive, that covers the nuclear issue, the ballistic missiles, advanced weaponry, the malign behavior in the region, human rights practices, treatment of U.S. citizens. We are open today to dialogue without preconditions. The President has signaled that consistently. We're ready to do that. But the goal would have to be a comprehensive agreement along the lines I said.
So the position still remains no preconditions. You're willing to sit down and talk today?
That's correct.
Lastly, let me sneak one last in for Mr. String, and I apologize for going backwards and forwards. I wanted to talk about this authority to protect partners. Now, I may disagree with you that there's a broad Article 2 ability to protect partners without congressional authority. But let's drill down on the existing 2001 authorization. And you have referenced that the 2001 authorization may give you broad authority to protect partners who are engaged in fights with us against the enemy. I would submit that you're right if they are engaged in fights against a named enemy under the 2001 authorization and that enemy has attacked them. But what about the case in which a group not listed in the 2001 AUMF has attacked a partner who's a partner in the fight against ISIS or the fight against al-Qaeda, but has been attacked by an entity that is not listed in the 2001 AUMF? Do you have any responsibility to come to Congress to launch an attack against that new entity, or is any attack against a partner of ours in the fight against extremism covered, our response to it covered under the 2001 AUMF? I think you're nodding, so I think you get what I'm asking.
Yeah, thank you. I appreciate the question, understand the question. So, Senator, what you've laid out is a very fact-specific hypothetical, and I prefer not to get into answering very hypothetical questions. I think what we've articulated in the testimony today is the first scenario that you mentioned, in that when U.S. forces are deployed alongside partners and allies, we have a right to defend our forces and those partner allied forces as they together are pursuing missions pursuant to either the 2001 or 2002 AUMF. So that was the core proposition that we're...
Right, but you're prepared to argue affirmatively in that hypothetical, but you're not prepared to say you do not have the authority in the case that they are attacked by an entity not named by the administration as a terrorist group affiliated with al-Qaeda.
Well, in some ways, so the answer that I provided is not necessarily hypothetical, because I can cite a couple examples where we've actually exercised authority to protect our own forces as they're engaging in certain operations pursuant to the 2001 or 2002 AUMF and come under attack by another group. For example, in 2011, U.S. forces were engaged in an operation in Iraq and came under threat from some Iranian-backed militia groups. And under the proposition that I laid out, our forces were able to respond appropriately to that threat.
Okay, I've gone over my time. Thank you, Mr. Chairman.